Most people who get referred to immigration court after their USCIS asylum interview make the same mistake. They assume that because they already went through the asylum process once at the asylum office, well, they basically know what to expect. They have their story, they know their case, so they figure they'll just show up and tell their story again, and this time everything will be fine. Well, that assumption has cost far too many people their cases, including people with legitimately strong cases who deserve to be approved. I'm going to show you exactly what court-ready supporting documents actually look like, why defensive asylum demands them, and what happens when they're missing. And we're starting right now. I'm Brian Manning, and I used to be an asylum officer with the government, and I adjudicated thousands of immigration applications during the 11 years that I worked for the government's two main agencies for asylum and refugee matters. But now, as an asylum lawyer, well, my law firm helps immigrants all over the country to secure their future in America through asylum. Let me know in the comments if you've got a case pending right now in immigration court, and I'd like to hear from you. Tell me, where are you in that process? Let me know whether you're waiting for your master calendar hearing, that's the first one, or rather you're waiting right now for your individual hearing, sometimes called the merits hearing. Let me know. By the way, if you haven't seen my video on what a referral notice from USCIS actually means, check out that video first, okay? The link is down in the description. So let's start with something that I can't stress enough, and this is for those of you who had an asylum interview at USCIS but were referred to immigration court. The documents that you submitted for your affirmative asylum interview are almost certainly wholly deficient for immigration court, and yet people make this mistake all the time. Here's what's different. Asylum officers are supposed to be objective fact finders. They're also badly overworked. Officers often get a file dropped on their desk just the day before the interview without sufficient time to really go through your supporting documents in any meaningful way. And honestly, the asylum officer may never even have read your documents, okay? And if they did, well, they might not have given them much weight, okay? Immigration court is the opposite. Two different people now scrutinize all of your documents, and they're scouring them for inconsistencies and other problems. It's an ICE prosecutor and the immigration judge. Now, the weaknesses in what you submitted to the asylum office, and I can almost assure you that they exist, they're far more likely to get picked apart in immigration court. And from my time as an asylum officer, I can tell you that judges give documentary evidence and legal briefs far more weight than asylum officers ever do. Now, let me be clear. In immigration court, you're defending your case against a trained government attorney whose entire job is to find weaknesses in your testimony, to exploit every inconsistency, and to argue in front of an immigration judge that you should be deported from the United States. By the way, if you want to maximize your chances for asylum success, then please be sure to hit the subscribe button and the bell notification so you don't miss the insights that I share on this channel. Okay, winning or losing a deportation hearing often comes down to the quality of your supporting documents. Allow me to describe the standard for court-ready supporting documents, as this groundwork must be established well before your appearance in front of that immigration judge. Now, the first document that your asylum attorney needs to build is your declaration. This is not just any written statement. It's a court-quality declaration that you need, okay? In the affirmative asylum process with USCIS, asylum officers are specifically trained to scrutinize how your personal statement was prepared, and heavy attorney involvement in drafting it can actually raise fraud concerns. Immigration court, well, that's completely different. You see, in immigration court, it's normal and even expected for the attorney to work closely with you to draft your declaration together. Your attorney needs to understand every detail of your story, every date, every person involved, every threat that you received, and every reason you cannot go back to your country. They need to translate all of that into a declaration that holds up under aggressive cross-examination by an ICE prosecutor who's looking for any opening to undercut your credibility. Now, that document, the declaration, it takes time to build it correctly, to build a great one. It does not get written in just a couple days, okay? And it shouldn't be. The second element that your attorney needs to develop in your case is your evidence, okay? In immigration court, evidence is not optional, it is expected. The ICE attorney is going to challenge what you say on the stand, and the immigration judge is going to weigh your testimony against everything the government puts forward. Every claim that can be supported with documentation, well, it should be. Things like letters from witnesses, medical records if they exist, maybe police reports, photographs, threatening messages, or communications that you've received. Any documentary proof that corroborates your story needs to be identified, gathered, reviewed carefully for consistency with your declaration and all other elements that you might submit to the court, and then it needs to be organized before your merits hearing. Inconsistencies between your declaration and other elements in your evidence are exactly what an ICE attorney is looking for. Preventing these issues is what your attorney is there for. But look, building a strong evidentiary filing takes time. Okay, the third element that you've got to master in immigration court is country conditions information. An experienced asylum attorney knows how to find credible, targeted reports from, for example, the U.S. Department of State, from established nonprofit human rights organizations, maybe from international bodies and respected, credible news outlets. And these reports can help document what's actually happening to people like you in your country right now. Now, this research has to be specific and purposeful, not generic. It has to connect directly to what you experienced and what you fear. And it has to be packaged in a way that the immigration judge can actually absorb and apply it, okay? This kind of research is not something that you can throw together at the last minute. All right, the fourth element is the legal brief. This is the document that your attorney writes for the court that explains the applicable law, applies it to the specific facts of your particular case, and argues clearly why you qualify for asylum. Now, your attorney uses the brief to connect the dots and influence the judge. The ICE attorney, the prosecutor, they can submit their own brief arguing that you should be deported. Now, your attorney's brief is your legal voice in the record, and a thorough, well-argued brief shapes how the immigration judge understands and approaches your case before the hearing even begins. Okay, so let me bring all this together for you. In immigration court, your attorney needs to build 4 elements: a court quality declaration, supporting evidence, targeted country conditions information reports, and a strong legal brief to tie everything together and argue your case. Every one of those items takes time to produce, time that you have right now before your individual hearing happens. And I'm telling you, that time disappears quickly. You look up and the filing deadline for supporting documents will be upon you. And every week that passes without an attorney actively working on your case is evidence building time that you'll never get back. Look, I've seen winnable cases end up losing because the supporting documents were rushed, not enough time for the declaration, missing evidence, country conditions research that never got done. And look, I've also seen difficult cases meet with a good outcome, an asylum approval, because the supporting documents were thorough and expertly done. Getting started early can make all the difference. So use the time that you have right now, okay? Get started today. If you're ready to take the next step and get help with your asylum case, then please call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us right now to schedule an asylum strategy session so we can help you to secure your future in America through asylum. Again, I'm Brian Manning, asylum lawyer and former U.S. government asylum officer, and it's an honor to serve you in your asylum journey.